So, good morning, everyone. Also from my side, my name is Busse. I'm from DKFZ in Germany. And I had the honor over the last 1.5 years to co-lead legal and ethics together with Tanya Bubalo from SFU in Canada. So our working group, so this talk will be split. I will present generally the working group in 5 minutes, and then Alex Bernier will take over. Next slide. Or do I advance those myself? This one? Okay. Well, modern technology. Good. So very briefly, what is the working group? What is the working group doing? What are the goals, and what have been our activities, and what do we want to do next? So purpose of the working group is to address issues regarding legal and ethical standards for the AIRR community. Right now, we're a rather small working group. We only have 8 participants, which you will see here. Demographic is relatively mixed. We have 5 people from North America and 3 from Europe, and most of the subscribers on the email list are actually also actively joining our calls. If you remember our meeting in the virtual meeting in December 2020, we had a rather long list, but then in a post-COVID world, most of the people in the working group struggled a little bit with getting their teams, faculties, and the rest of their lives back to adopt to post-COVID. So we said, okay, so this was maybe a little bit too ambitious. So let's focus on one legal issue that is really important. And this was to understand the restrictions on data sharing imposed by European database protection laws, which is the EU directive 96/9/EC. And so for everyone who now thinks, okay, 96/9/WTF, this is the piece of European legislation that protects IMGT and gives its monopoly over germline sequences to a certain extent. That extent is what Alex will elaborate on. If this piece of legislation falls, that monopoly falls. If this piece, if there is a carve out for it, the monopoly falls. So once again, this is human law. This is not thermodynamics. Talk to your representatives that this should be changed, because this is the disputed part or a disputed piece of legislation, and this is something that we as a community or as individuals can lobby for, that this is actually damaging to a certain extent open science, at least in this case. Okay, so what are our goals for next year? We plan to finalize and publish the piece that Alex has been writing, which is, so there will be 2 things. There will be a longer manuscript directed towards legal experts, and then a brief or a much shorter summary for life science scientists. We want to get back on the plan to conduct and evaluate, so to conduct a survey to understand what are legal obstacles for people to share data. Is this because it might damage their IP? Is it because there are questions around GDPR? Is it something that we don't have on our radar? I think this is something very important for us to understand as a community. We would like to provide some guidance on potential GDPR issues. There has been some movement about the question about re-identifiability of repertoires over the last couple of months. So there was a paper from the Vulture group, which would be interesting to have a look at. And then a couple of additional things would be ethical frameworks, especially for studies involving indigenous people, then legal and ethical aspects for open sciences practices. And this is something to do with other stakeholders like RDA or IUIS. And what Susanna already mentioned before is that we would like to team up together with diagnostics and meeting to organize an event regarding legal and regulatory questions for covering AIRR-seq and AI machine learning. Okay, so with this one, okay, so products, I already mentioned those ones. And so I will step down after the cycle. Tanya is willing to co-lead, and we're still searching for a new co-lead. So if there's anyone interested, please let us know. And with this one directly, I would like to hand over to Alex.
Hello. Okay, brilliant. Can everyone see my slides? No, I think, okay, they're there. Brilliant. All right, let me just put this in slideshow mode. So essentially what I'd like to do today is take a few minutes to talk about the findings of our research and specifically the implications of what's called the sui generis database right. So essentially that intellectual property right that lies in databases within the European Union, the implications of that for public biological databases writ large. And so the first important consideration is what actually is the sui generis database right. Essentially, it's an intellectual property right that applies specifically to databases in the EU. And we use the term database here, but actually this is essentially any kind of structured information or data set that's been compiled through human endeavor. So even though we speak about databases, we don't expand our definition to really include only the traditional technological database that's really hosted on an informatics system, a computer. This can really be anything that contains compiled data and has some kind of mechanism to sort through it. We could even think of phone books. The sui generis database right essentially protects against two things. It protects against extraction and it protects against reutilization. So any act that takes a substantial part of a pre-existing database and either reproduces it on another physical or digital medium, or that takes that database and makes it available to the public in a novel form could constitute extraction or reutilization. And if this affects a substantial part of the original database, then this would be considered to breach the sui generis database right. So as we can see, it's a fairly broad right. And if we think about open science infrastructure or public biological databases generally, we immediately see two major red flags, two areas for concern. And so the first one is that it's a common practice in the health sciences to repurpose some amounts of information from existing public biological databases, whether they be open science databases or other, in a new infrastructure. The second is that it's very common as well to produce value-added services. So here we can think of things like meta search engines, discovery platforms, any kind of tool that sifts through existing data and presents results that are drawn from a large number of databases or otherwise makes them more findable, accessible, interoperable, or reusable. Any of these activities theoretically could breach the sui generis database right, because taking data from an existing database, placing it in a new one, or in the alternative, creating a platform that enables the search or analysis of existing data that's held elsewhere does appear to involve either one of these two acts, which we've discussed. So again, extraction or reutilization, taking it, hosting it somewhere else, or in the alternative, taking it and making it available to the public in a new form. So on a first reading, we immediately see that there's a tension between this sui generis database, right, which is meant to protect individuals and give them rights that can be commercialized or used for the purpose of ensuring exclusivity in data that they've made the effort to bring together. And then on the other hand, this countervailing imperative to make data as open as possible, to enhance its economic value and to make it available to a larger number of communities of researchers. However, the research that we've performed over the last year and a half does indeed attempt to find out if there are certain exceptions or limitations to either the ambit of the right, so what it protects, or the application of the right, so the kinds of acts that infringe it, that would cause this to be less of a concern for scientific community. And by and large, we've found that in actuality, it probably isn't a major problem for scientists that are involved in repurposing public biological data for the purpose of creating new databases or new value-added tools. The first reason is that there have been a number of carve-outs to the conditions in which the database right applies that make it less of a risk for scientific communities. So the first consideration is that the database only applies where there's been a substantial investment in compiling the database. Now, this investment needs to be in compiling data from existing sources or in making efforts to obtain, verify, or present the data. Efforts that are made, investments that are made to generate data in the first place do not qualify for sui generis database right protection, which means that the prototypical example of a scientist generating data for the first time in a wet lab probably wouldn't lead whatever data ensued to be protected under the sui generis database right. There's also a need to demonstrate that the data wasn't created as a byproduct of other activities that were already underway. So for instance, if a research institution or a health research sector or institution had generated clinical data or biological data as part of something that they were already going to do, so not for the purpose of compiling this database, the database wouldn't be protected. And then thirdly, there also needs to be an interest in recouping on one's investment. So essentially, in those circumstances where there is no real investment risk that's born in creating a database, or in those circumstances where, for instance, the data was generated in the interest of providing it to the public sector, it's very likely that it won't be protected. Taken at large, these exceptions seem sort of arcane and arbitrary, but there's a really simple guiding logic that runs through all of them. And it's simply that this database right is not created in the abstract. It's meant to protect databases, but only insofar as that protection is needed to stimulate economic activity. Only insofar as that protection is needed to encourage people to create new databases, which means that in those situations where there is no investment risk, or where the database would have been created anyway, the law, and this is vehicled through the decisions of courts, the law will typically choose not to offer protection. And then if we think of that first example, wherein there's a carve out from the application of the database,
Alex, right? We need to speed up a little bit.
How long do we have, Christian, roughly?
2 minutes.
2 minutes? All right, brilliant. So all this to say then, that because the database right is intended only to protect those investments that wouldn't have happened without this database right there to protect them, it's actually very narrow in those circumstances in which it will arise. The second element, so this is the second half of the test, stipulates that only those acts of extraction or reutilization of an existing database that would put the original investment at risk are infringing. So essentially, even if you reutilize, even if you copy an existing database, it wouldn't typically be categorized as infringement unless one could show that the original database was essentially deprecated, was essentially made useless or less valuable by this new copy. And so what that means is that pure attempts to create a parasitic copy of an existing database or simple meta search engines that just replicate existing underlying databases could well be found in infringement. However, tools that provide value added, tools that have a unique or additional functionality, so for instance, discovery platforms that provide richer or better metadata annotations, things like that, will typically not be found to infringe the sui generis database right. That's the majority of what the findings we had to present.
Sorry, Alex, we have to close now.
Okay, well, brilliant. Well, then I'll leave it at that. I'm happy to, yeah, if there are any questions, I'm happy to field them, but if we're over time, I'm happy to leave it there as well.
Okay, cool, thanks. Yeah, so again, everyone, please look out for either the full paper or the, what is this? Either the full paper or the summary. Thanks a lot, Alex, for doing all that work. I mean, this is really very going into very lot of detail. So are there any questions? William?
What are the next steps for the community when we get the advice?
See on how risky it is to just copy IMGT, because we do have, everything is in the Internet Archive, most of the things. The question is whether this infringes or not, and make a sound judgment whether we can risk this or as Alex alluded to, the question whether there could be this enriched search engine. I mean, this is another possibility. But again, so I mean, thinking about the things that we would like to have, or these additional features that we would like to have for a germline database, I think that enrichment would be a pathway, but we need to understand closer what it really needs to be to get on the safe territory.
Thank you.
Okay.